Thank you. In advance of a conference that iTech Law is hosting this May in San Diego from May 14th to May 16th. Our hope is that many of you, after watching the webinar today, will want to explore iTech Law and consider attending the conference. To make that possible, I'm going to be putting into the chat a link to the iTech Law conference webpage, a flyer about the conference, and my email address in case you have any questions that you would like to reach out afterwards. With that, I would like to get this started and turn the discussion over to Sandra Jeskie, our moderator today and a former iTech Law president herself, to further introduce herself and get the panel going. Thank you. Sandra?
Thank you, Jason. As a former iTech Law president, I can just attest to the value and the collaboration amongst the people that you will meet at iTech Law. So I do hope that you take advantage of that. So my name is Sandra Jeskie. I'm a partner at Duane Morris. I lead the technology, media, and telecom group, where I specifically focus on privacy, security, AI, emerging technologies. I'm also a very active arbitrator, mediator, and special master to the court. I'm so happy to introduce panelists with me today. Here are Dr. Nils Lölfing from Germany, who focuses on AI with a decade of experience in EU data laws, product safety, liability. He speaks regularly at the most premier conferences, contributes to publications like the International Handbook on AI Law. We have Marr Lehemite from France with over 12 years of international legal experience in telecom, energy, Web3. She specializes blockchain, AI, impact-driven projects focusing on ethics and compliance. And finally, but certainly not least of all, we have David Marr from the US, who is vice president and legal counsel at Qualcomm Technologies, where he leads its open source legal practice and policy team. David has deep experience in open source software, AI, and data sets for AI training. So very impressive group we have here today. So let me set the stage a little bit. In 2024, we saw a remarkable acceleration of AI regulation around the world. Now, here we are only a few months into 2025, and we've already witnessed a breathtaking amount of change in AI regulation. Shortly after his inauguration in January, President Trump rolled back Biden's administration's executive order on AI. The Trump administration is also emphasizing deregulation. We've seen state lawmakers in the US stepping in to fill those gaps in AI legislation. The world has also witnessed the unexpected arrival of DeepSeek on January 20th of this year, when the Chinese company released its first open source reduced cost AI model. In recent months in Europe, we've seen the European Commission withdraw the draft AI liability directive. We've received important feedback from the AI Action Summit in February, what was hosted in France. And there's a lot of uncertainty about the data privacy framework, among other things. So a lot has happened, and we are only at March 6th. It's almost unbelievable. So we have a lot to discuss. So let's get started. So I'm going to start with Dave. Dave, as noted, we've seen an extraordinary amount of changes in the last few months. Can you summarize where we are today in terms of AI regulation in the US?
Yeah, thanks, Sandra, for that lead in. As you noted, there's been some kind of rug pulling happening on the executive order side, right? You had the Biden executive order, and then, when Trump came in, then he immediately sort of like overturned that. And then there was also this White House blueprint on AI that ended up, that's more like a, best practices approach. It wasn't normative. But nevertheless, that was also connected potentially to the Biden executive order. So people still aren't at this point unsure whether that blueprint still survives. And if you look at the executive order that Trump put in, his replacement executive order to the Biden one, it was very high level. Okay, it contained things that was really kind of like we're going to start looking at these things. We're going to re-examine these policies to see if there's anything that conflicts with this approach, it's more about call it American leadership in AI. And so you're going to see some of those ramifications still kind of play out. There's some time left for those agencies to be re-examining the things I might have already put in place, under the Biden executive order. The real action in the states, or in the U.S., is actually happening in the states. And for that, I'm going to talk about 4 big buckets of state laws, and there are a lot pending in these, in the states. There's like over 200 at various stages, but we already do have some laws on the books. And the 4 categories I would sort of organize, this talk in, from at least my portion of it, is consumer protections, and then employment related. And then there's another bucket I would say is kind of targeting big AI use cases. And then there's these kind of bespoke ones, kind of like targeting industry verticals, such as like healthcare. When you call up your healthcare provider, if you're talking to an AI, then they need to tell you those kinds of things. And that's going to be sort of like, kind of like very, very differentiated practice across these different states. And the real challenge in the US is going to be, how do I actually have deploy an AI product or a service across all 50 states and not run afoul of things? And it's going to be hard. So just to give you a flavor, there's a couple big ones, in Colorado and Utah. Those are around consumer protections. And so if you're looking to sort of understand that, I would examine the Colorado concerning consumer protections and interactions with AI law. And then there's also the Utah Artificial Intelligence Policy Act. To give you a little bit more of a flavor, the Colorado law, it's about algorithmic discrimination for the use of high-risk AI systems. So that law is, it's passed. It's going to be in place as of February 1, next year. So what are high-risk systems? They're systems that can substantially influence consequential decisions affecting consumers. So what's a consequential decision? Well, those are actions related to a field of different things, like education, employment, like lending and loans, government services, healthcare, housing, insurance, legal services is also in there. And so if the algorithm in the AI thing, results in discriminatory treatment of a protected class, and for that, think of like race, gender, religion, then that use would be prohibited. So that's a no. There's no way to save that. You just cannot provide a service that provides that results in that discriminatory treatment. And that's both treatment and impact. So if either one is triggered, then that needs to not be at least been made available in Colorado. And then so that we have some runway on that. Again, that's February 1. One that's kind of like already like on the books is Utah's law, and that kind of required some companies to do kind of a bit of a scramble. That was focused more on Gen AI, and it says that if you're a consumer and you're interacting with a Gen AI system, then there needs to be some really big conspicuous disclosure, like on the website or in the UI, so that the consumer knows that this is an AI interaction. And so those are consumer facing. And just real quick, so examples of employment in the second bucket would be like Illinois. Okay, Illinois has this law called Human Rights Act, and they amended that law to add an AI provision. So the Human Rights Act is mostly about the workplace. And so this amended law says that employers can't use AI that causes a discriminatory effect on a protected class, similar to the ones I just talked about in Colorado, except Colorado was obviously about consumers. This is now about employees. So there's various aspects of ongoing employment, such as like promotions, training, discipline. There's other things that affect employees day to day, that all those things cannot have a discriminatory impact on those protected classes. And there's also disclosure requirements, like you have to tell the employees, when AI is being used. And so that's like, the day to day. Illinois also happens to already have a law in the books for the hiring process. So if you use the AI to examine the video interview process, so if you're doing a video interview and there's some AI process, either live or, post-processing, then you got to tell that applicant, so many days in advance, and you can't use it unless you explain how it's going to be used and get the consent. So
Thanks,
first thing,
Steve. As everybody can see, this is, in the US, we have this extraordinary patchwork quilt, if you will,
yeah,
of laws in so many different elements, in different industries or different, employment law versus, various other laws that might be more associated with other businesses. So let's turn, in the interest of time here, to
yeah,
Nils. And so we've heard a little bit about the US approach, and how it's kind of emphasizing deregulation and kind of moving it to the states. And that's a notable contrast to the approach taken by the EU. So how is all this impacting the EU, if you can briefly discuss?
Thank you, Sandy. Yeah, as you know, indeed, the EU is actively regulating tech, and that's contrasting starkly with the US approach, which rather, as we have heard, emphasizes deregulation despite all the state laws David mentioned. Unfortunately, in my view, the EU isn't fostering technology as much as regulating it. However, and that's important, there are signs of deregulation also emerging. And I will try to outline this picture in my response as briefly as possible. Firstly, in terms of regulation, there is an AI package of AI-focused regulations from the EU in terms of EU product safety and EU liability regime. Regarding product safety, we all know the flagship AI regulation, which is the AI Act, which entered into force last August and will be applied in stages. It takes, as you probably also know, a risk-based approach in determining applicability. So that differs quite significantly from the GDPR, which is often dubbed also as the law of everything due to its broad scope, as everything probably almost often involves personal data. But in fact, the AI Act won't affect the majority of AI systems. So it only sets requirements for prohibited practices, specific high-risk AI, general purpose AI, and transparency. So I therefore believe it's a game changer only in narrow or for narrow AI systems, especially those labeled high risk products and relevant to specific sectors, which must then integrate new requirements into their design really. And that's the challenge here, such as data governance requirements, AI risk management, and human oversight. And that includes, for example, medical devices and sectors such as robotics, finance, education, critical infrastructure, biometric use cases, but also HR. So it's spread across a variety and broad range of sectors and products. And the challenge here in practice is really to identify the AI systems which are covered by the AI Act. And just briefly on the Act stage application, that means, for example, that as of February this year, the prohibitions on prohibited practices like subliminal messaging have been enforced. And the EU Commission is also to support the interpretation of that very new law, is also working on guidance, though it has been criticized pretty much for being or providing only very underwhelming guidance. For example, 50 pages of guidance on prohibited practice recently without, however, a clear direction on fringe cases. So that has turned out to be not so useful for companies in the EU. And then looking into DeepSeek and the AI, that qualifies as a general purpose AI model under the AI Act, and the EU is currently discussing a code of practice to help providers of these AI models to meet the requirements. So it should also be more actionable through these code of practices. But it's interesting to see how this develops, because there is currently a specific threshold for GPAI labeled as systemic risk. It's measured in floating point operations. And currently there is a 1025 flops floating point operation threshold for AI, GPAI considered as systemic risks. But looking into DeepSeek and these models they offer, which are more efficient, there are currently discussions around whether or not to reduce this threshold to also catch those systems which may not meet this threshold but are still very impactful in terms of their engine, like for DeepSeek. And to conclude, and returning to my introduction and the science of deregulation, we have also seen the EU adopting the AI liability directive, which you, Sandy, mentioned, But that has been repealed, in fact, and that's a very rare thing to happen in the EU, that actually a law which has been proposed by the EU is repealed, but that's a sign of a deregulation effort from my perspective, possibly also indicating further deregulation, which is also confirmed by the fact that the EU is currently also trying to simplify the AI Act for SMEs. And please allow me one final comment on investments in the EU. This is obviously not as high as in the US, but also that gained traction with AI gigafactories, which shall be established in the EU, and also much more budget than it has been before in the EU. There was quite a reluctance in the EU to invest in AI properly, like it has been done, for example, in the US. And overall, while in my view, the EU remains focused on regulation, there is a realization that to reap AI's benefit, it should better balance this with deregulation and investment, perhaps aligning more with the US approach, though this is obviously also still very distinct.
Thanks, Nils. I mean, it seems that this deregulation is starting to kind of evolve around the world. And I know recently France hosted an AI Action Summit, in fact, in February, bringing together heads of state, government, international and domestic business leaders, academia, and others. So one of the most pressing issues, as I understand it, Marie, was that AI regulation and its impact on innovation was supposed to be a big topic. What do you know that has come out of this summit? I mean, is there anything interesting that you can tell us and make some thoughts there?
Yes, thank you, Sandy. Yes, indeed, and it's a very good transition to what has been said by Nils. I think that we are trying to overcome this issue with regulation with a lot of investment and new budget in this area. So to come back to the AI Action Summit, it took place indeed in February in Paris, gathering over 1,000 participants from more than 100 countries. People from private sector, public sector, but also foundations and academical representative. So it was a major event co-organized by France and India. And this is important to say that the two countries organized that together. There has been 5 key discussion themes in this summit. It was AI for the public good, the future of work, innovation culture, trustworthy AI, and a global AI governance. From that summit, there has been 3 key announcements. Even the launch of the Current AI Foundation, which is a non-profit organization with an initial investment of 500 million euros, with a goal of raising $2.5 billion over the 5 years. The funders are mainly the French state, but also companies like Google and Salesforce, and foundations like MacArthur Foundation or the Ford Foundation. The objective of this Current AI Foundation is to build a diverse ecosystem with a private sector, public sector, and foundations all together, and to promote especially open source AI and a very high quality data set. So this is the first announcement, the first investment announcement. The second investment announcement came from France with an investment of 109 billion investment from France in AI and data centers. The most significant portion of that 109 billion euros investment will be allocated to building of data centers. And France already identified more than 30 sites in France where we can build huge data centers. You can ask why data centers in France, and why is France investing that much in infrastructure, and especially leading how can I say, data centers are very linked to the energy consumption. It's just because France relies 70% of France's electricity consumptions comes from the nuclear production, which is very, it maintains sustainability, energy security. So Emmanuel Macron, during its introducing speech, did a wink to Trump, because as you know, Donald Trump, Mr. Trump campaign slogan was promoting oil and gas drilling. He said, drill, baby, drill. And Macron countered and said, here, there is no need to drill. Here, it's just plug, baby, plug. So that's what we do in France because we have sufficient energy and we are quite proud of our nuclear energy provision in France. The third initiative is an EU-wide initiative, the Invest AI initiative. It's a 200 billion fund, to be made by the EU, focusing on 4 gigafactories to train large-scale AI models and to strengthen the AI infrastructure across Europe. At least there has been a declaration on inclusive and sustainable AI, which has been proposed to the several countries. 58 countries, including France, China, and India, signed this declaration on inclusive and sustainable AI for people and the planet, with different priorities from enhancing AI accessibility or for AI open, transparent, ethical, and secure, or avoiding market monopolies, for example. So many topics in that declaration. At the end of the day, neither the US nor the UK signed the declaration. For the UK, it was they argued that the declaration was not clear on the framework for AI governance, and it did not address the national security concerns of UK. Concerning the United States, Vice President Vance criticized it a lot, the EU regulatory approach, and warned that the excessive AI regulation could kill the industry. So that's why the US didn't sign that declaration. These are also the main takeaways from that summit and the 3 announcements for investments and that declaration actually.
Thank you, Marie. Interesting. Again, it shows how some of the deregulation pieces are actually working their way around the world. So just a few months ago, as I mentioned, with the Chinese AI startup DeepSeek grabbed headlines with its new large language AI model that would compete with more expensive leading AI models by using older and less powerful chips at a fraction of the cost of the US models. So this has sparked a great deal of legislation activity in the US to address security concerns and questions about the speed in which DeepSeek was able to come on the scene. Dave, I know you've thought a lot about this. What are your thoughts with respect to DeepSeek?
Yeah, thanks, Sandra. DeepSeek was definitely a surprise for the entire AI industry. And just to illustrate how much of a surprise, let me just recap, the January timeline, right? So in January of this year, the US, just before the transition from Biden to Trump, published this export framework. They called it the Framework for AI Diffusion. And I can talk more about that, but it's mostly based on hardware restrictions and tiering of different countries, into 3 different tiers. But then just like exactly a week later, then DeepSeek R1, that's the reasoning model, that was released. And the reaction wasn't immediate. Okay, that took a week, another week for the industry to sort of react. But then like the day after DeepSeek was released, Stargate, this is this, initiative. It's a private, investment, program around AI. The Stargate initiative was announced. And that was like, okay, we're going to spend $100 billion, through private investment. And then we believe that we're going to be able to get to another, a total of 500 billion, so it's like, it was like, kind of like, hey, we've got so much money and we're going to spend it, it's going to be big. But then right about, a few days later, when DeepSeek, researchers, started to come out with, not DeepSeek research, but the industry researchers started to examine the DeepSeek code. And by the way, DeepSeek, it's not just, the code, they've got the weights, they've got the methods. It's very open source. And there's degrees of open source that we can talk about if there's interest in that. But it's very disclosing as to what it does and how it does it. But the researchers are coming out and saying, actually, this thing is so small, it's so efficient, and it's so good. So that obviously has big implications on the underlying technology approaches and the business models. And by the way, DeepSeek recently, I think just yesterday, announced their earnings, and they're pretty good. It turns out running a much smaller, efficient model with much lower inference costs really helps with the gross margins on the compute side and the inferencing side. So they have really good margin numbers. So how does that impact U.S. policy? It's obviously going to, to make everyone wake up in the U.S. Certainly, the people that were the promulgators of this framework for AI diffusion, they're going to be like, we've been focused on hardware the whole time. And it turns out DeepSeek as a company, they actually already acquired a whole bunch of, older generation chips because their parent company, it's a hedge fund in China. Their business was algorithmic, trading of securities. And so they had a bunch of these machines crunching away to try to get their algorithmic trades in faster than whoever their competitors are. So they had a small data center, not a huge one, but a significant one, and that's what they used. So then the question to all of us is, how does that change going forward? To the point that Dr. Lölfing actually illustrated. By training on much smaller hardware footprints, that obviously gives advantages to folks that maybe don't have access to as much hardware. And that's not just China, but it's also this tier 2 countries I mentioned. Poland is, kind of stands out as one of the bigger folks that complained that they're in tier 2. And then, also, how does that, affect the investment levels underneath all this stuff? So it's possible that now, there's a whole different approach to doing these things they call distillations to come up with a more efficient way, to still be competitive against some of the larger players.
Well, DeepSeek is such an interesting topic. It's very helpful. And I think this extends also to Europe. And so, Marie, Chinese AI companies like DeepSeek are obviously not limited by the same privacy and IP protections that we might have either in the US or in the EU. How are European regulators responding to DeepSeek, particularly as it relates to the processing of personal data of European citizens?
Yeah. DeepSeek has been well noticed in Europe, even because of their GDPR concern. Actually, AI inherently raises concerns regarding data privacy due to the large-scale processing of personal data. So, and whereby GDPR emphasizes the data minimization, transparency, and purpose limitation. So, as before DeepSeek, there were already another case with OpenAI. It was in November 2024. So it was the precedent. And in that case, OpenAI was fined 15 million euros by the Italian Data Protection Authority for GDPR violation. It was especially because of a failure to notify a personal data breach. But also for the unlawful processing of user data and at least the lack of transparency in processing the data. Quite naturally, the Italian Data Privacy Authority addressed the same points to DeepSeek, and on January 30th, 2025, they just blocked DeepSeek in Italy because of some concern about personal data collection and use. The issues that they noticed, that they identified, were especially a lack of transparency regarding the sources, the purpose, and even the legal basis. And they also identified that the data were all stored in China, which raises concerns because any transfer out of the EU has to be authorized, or there is a specific framework for that. And there is no equivalent recognition from the Chinese law regarding data privacy, of course. And also there were insufficient guarantees on user data processing, and at least there were no representative of DeepSeek in the EU. And this is a sign of it leads to legal uncertainty, because then the regulator has no person to address to, and that's the reason why normally there is always an EU representative of this company. At the same time, several European regulators tried to address also the case of DeepSeek. In Belgium, for example, they started a formal investigation against DeepSeek. In France, Croatia, and Ireland, they just requested additional information. Germany, Luxembourg, and Netherlands, they are considering investigation. And but other countries, they didn't take any official actions. There has been one complaint in Portugal, but no action yet in Portugal against DeepSeek. So this is a state of the art regarding DeepSeek and what the European data privacy regulators are doing. At the same time, as we said, that DeepSeek raised a really concern about the transfer of personal data outside of the EU. It has to be noticed one point is about the data privacy framework, which has been made between the EU and the United States, ensuring the transfer of personal data. It should be noticed that the decree which established that data privacy framework is maybe about to be deleted or is at stake currently. I think the decision should be made today by the Trump administration. And the Trump administration apparently would like to erase that data privacy framework in order to even enhance the AI industry as a matter of deregulation, as we talked about earlier. So I don't know if it is a pending decision currently in the US. Let's see, but definitely if the EU-US data privacy framework should be erased by today, there would be a huge consequences. I know that the European Commission should take position on it on March 19th. But if EU personal data are not able to be brought to be sent to the US, it could be a huge impact for all the businesses, definitely. So this is the same, the data transfer outside of the EU, and again, for AI purpose.
Thank you, Maria. It's an excellent point. I mean, the data privacy framework is so integral to multi-jurisdictional businesses and how they do business, and it really kind of throws things up into the air, as well as so many other things that are happening. So as you can see, the breaking news that relates to even AI as we speak. So it's very important to keep watch on that issue. Nils, in light of what Marie was talking about in terms of DeepSeek enforcement in various countries, what lessons can be drawn about GDPR compliance for AI companies, and how do you think that might influence future enforcement actions across the EU?
Thank you. Yes, I think the Italian enforcement action, especially towards DeepSeek, which Marie explained, has broader implications from an EU perspective, in my view, because it follows an opinion by the European Data Protection Board, the so-called EDPB, which provided an opinion on the development and deployment of AI models under GDPR. It's just published last December, so it's pretty new as well. And the EDPB, which is the joint body of all EU data protection regulators, typically issues guidance with significant influence across the EU. So that's quite important with this opinion on AI model development and deployment. And overall, you can say that the EDPB opinion provides valuable insights also into the lawfulness of web scraping, for example, for AI model development, but also around the requirements for integrating third-party AI models for deployers, which is a very common thing nowadays, so important for many organizations in Europe and abroad. However, and that's also something which I'd like to point out, it allows local regulators considerable discretion, which means that there is no harmonized enforcement view expected from my perspective. Rather, in my view, it places the opinion itself, and as such places a very high burden on developers and deployers of AI models. For instance, and to give you some flavor on this point, AI developers using publicly available data for AI development are, under this guidance, advised to implement onerous technical measures to justify the AI development and training. Technical measures like data masking or unlearning techniques to avoid GDPR implications during that AI model training. And it's not getting better for deployers who try to integrate these third-party AI models, for example, large language models. They also carry their burden with GDPR requirements under this guidance. They are, for example, tasked with verifying the lawfulness of the third-party AI model developers' activities. So they essentially are supposed to vet whether the development of the AI model in the first place, which they are going to integrate, was lawful. But how should they do that? In practice, I think that is hardly feasible and to say the least, very challenging. But I think that that's not a way forward for many organizations to vet their AI models in this regard, in regards to the AI development. And overall, the EDPB opinion and the Italian guarantees actions, the guarantee is the Italian data protection regulator regarding DeepSeek, highlight that data protection regulators see themselves more and more as the de facto regulators of AI systems, and thereby also setting quite a high bar for GDPR compliance. It also shows, from my perspective, that GDPR is, at least for the majority of AI, more important than the AI Act itself, because it's just much broader and applies to any AI system. And looking at the requirements, for example, the EDPB has established, it's quite onerous to really comply with it and ensure GDPR compliance. And finally, companies subject to GDPR should adopt a risk-based approach here. As said, achieving 100% compliance is unlikely if local regulators, for example, would strictly adhere to the EDPB guidance without any leniency. So this is, from my perspective, really balancing commercial interests with compliance, and you cannot achieve 100% compliance this way.
Thank you. I mean, as you can see, we've talked about a lot about regulatory enforcement, but it should come as no surprise. We've already seen a number of significant pieces of litigation relating to AI as well. So I'm going to ask each panelist to briefly summarize what's happening in their respective country. Dave, why don't you lead us off and talk about U.S. litigation in connection with AI?
Yeah, you bet. There's been a lot. So I would put U.S. litigation into, 7 buckets or so. Okay. I would say copyright infringement is the big bucket, and then copyrightability is another one. Privacy in connection with, these, AI, as my co-panelists have talked about, is a key issue there. Open source has gotten pulled in around what's appropriate as to when you scrape like GitHub, popular cloud sharing and developer portal, whether or not you can violate those licenses. Obviously can't, but there's the question is how much can you use? And then antitrust gets pulled in, defamation. Somebody's been complaining that their name has gotten mixed up with a similar but a different name of a terrorist, and now his neighbors think he's not a really nice person. And then right of publicity, that comes into big play, especially in the entertainment industry. And there's bespoke laws actually on all these little areas that predated AI, and there's some ones that are Tennessee recently came out with one that's specifically on some of these things. But the big bucket, as I mentioned, is copyright infringement. And within those cases, there's 5 buckets of cases within that. Okay, there's the newspaper cases, like the New York Times, and there's a big case where that they, joined by 8 regional newspapers, they're suing Microsoft and OpenAI. There's the books cases, which has a bunch of prominent authors that say that their books have been scanned. There's the images cases, and Getty Images is probably the most prominent one that's enforcing their rights there. There's video scrapings from the internet. There's music, and then so all this stuff adds up to, frankly, quite a lot of litigation. Some of them have gotten consolidated. But if you're looking to kind of watch a case in this copyright infringement space, you might want to pick one of the newspaper or books cases. Those, to me, seem like they're most progressive and looking at fundamental issues as to how data can be used as input for training of the model. And then there's also the implications on the output side when somebody's like, oh, this provides a language that's identical to this language from the New York Times, or it was identical except for this one part where I got it wrong, and now I'm also going to sue for trademark tarnishing. So it's a really interesting space. But copyright infringement, and then this next tier I would say keep an eye on is copyrightability, because that also has a potential to either really accelerate or really decelerate the AI industry.
And I guess we're really just seeing application of existing laws applied to AI, and we have not yet gotten into the point where any of the AI laws that are just so recently on the books have any kind of litigation activity. Is that fair?
Yeah, there's been settlements, but when I looked at those settlements, they're all kind of resolved on, I would say, uninteresting grounds that don't provide good precedent or good inferencing as to where these other cases might be headed.
Well, thanks, Dave. Nils, what are you seeing from your perspective?
Yeah, thank you. The AI Act is obviously quite new, and it just gains traction in terms of litigation around the AI Act specifically, which is very exciting to anticipate. Very recently, one court in Bulgaria has referred a first preliminary ruling related to the AI Act to the European Court of Justice. And this case, just to explain on this and give you a flavor of this first case, which is very exciting for many in the EU, this case involves a company using an automated billing system towards consumers, where the basis for the charging decisions could not be determined even after an expert analysis. And the referring court now in the EU seeks the guidance from the European Court of Justice on the application of the right to explanation in the AI. So there's obviously a right for consumers to have certain decisions made by an AI system be explained to them. And this is supposed to provide access to decision-making processes, especially for high-risk systems. So the one which are explicitly called out in the AI Act as being more impactful towards consumers as probably other systems which are also AI-based. And the question here is whether consumers can demand that an AI deployer or user can or has to disclose detailed information about, for example, the specific AI functions, the source code, the parameters on which the AI provides its decision, the algorithm, and also the overall decision-making progress. So as you can already see from these points, that would quite have some impact also on AI deployers and the entire AI supply chain. Just to compare that briefly with GDPR requirements, GDPR case law previously has denied access to the source code, for example, under the so-called automated decision-making requirements of the GDPR, stating that only high-level information is required in terms of what needs to be provided to individuals subject to such an automated decision. And last week, indeed, the CGEU on this GDPR case clarified that while the algorithm itself does not need to be provided, a simple explanation, including all relevant information, is enough. So that shows that things like algorithms or the source code does apparently not have to be provided under GDPR, but we don't know yet how this will play out under the AI Act, because this decision hasn't been issued. And this ruling will, in my view, set a crucial precedent also for all companies in the in the EU leveraging AI, especially in terms of AI, which is supposed to facilitate automated decision making. And if the European Court would align with the consumer's argument who claims this information from the AI deployer, it could mean, for example, increased obligation for algorithmic transparency and disclosure, but also stricter compliance requirements for AI-powered services, which could then again have significant implication as companies might be compelled to disclose proprietary information to consumers. However, in the end, I have to say, I don't think this interpretation will ultimately be enforced in that way. And it's more likely that the CGEU will align with the GDPR, with the established GDPR rulings, which say that you only need to provide relevant information, but not the source code and other things which could be labeled as proprietary. But as you say, you never know how this turns out, and it will be exciting to see what the final decision will be.
Thank you. Very interesting. Marie, what are your thoughts in terms of litigation connection with AI?
Actually, the different litigation cases across Europe have been mentioned by Dave. We find a lot of copyright litigation, but actually the judges are just interpreting the current laws, the copyright laws and so on, and they are using the definitions which have been made for the AI Act, meaning we are using the newest knowledge we gain over the last years on AI to apply on the different cases. But definitely most of the cases are IP copyright litigations, especially for books and newspapers and so on. I don't see that much litigation on GDPR unless for a violation of data. Leakage. In case of leakage of data, but that's it. But not that much. I think it's not mature enough to raise that much an action against AI provider, but definitely copyright is a right fit for that.
Well, thank you. As you can see, we've covered so much in terms of what's happened, and by March 6th, it's pretty incredible, I think. Let's wrap up in the last 10 minutes that we have together, asking each panelist, what are your expectations about AI regulation or even litigation in the rest of 2025, given the changes that we've seen? I'm going to start with Dave.
Thanks, Sandra. I think that in the US, it's going to get just more messy. The reason why I would say that is because there's no prospect at this point of any federal legislation taking place in any realistic way in this year. As a result, you'll see various politicians, for their own purposes or for benevolent purposes, try to create their own, bespoke approaches. The litigation will just continue to proceed. I think that we're a ways away from seeing anything precedential. Maybe 2026, but maybe there's going to be something that later this year. But it's going to be messy. If you're looking for like a full employment plan for lawyers, AI is the right place. So you're guaranteed to have interesting questions from your clients if you're practicing in this space for at least the remainder of this year. It's just going to get more and more interesting. And frankly, it's hard to predict what Trump's going to do next, and that adds another kind of wild card to the mix.
Very, very good points. I've always said as well, I think we're in a very different stead than Europe, who was able to come out with the EU AI Act because they already had a, comprehensive data protection law that we don't have in the US. I don't know, or is that your thoughts too? It just feels to me like there really has to be federal legislation in terms of privacy that would be the foundation for AI. But I'm interested to hear your thoughts on that.
I think that the adults in the room right now, are the Europeans. Okay, I think that you're going to see, low regulation, be the norm in the U.S. at the federal level. Even when it does arrive. That's my personal take. you can put me back in 18 months and tell me if we're right or not.
No, I agree. I don't expect to see either federal privacy legislation or some comprehensive AI legislation in the US, at least this year. So we'll see. All right, Nils, you want to give us your last thoughts on expectations for the rest of 2025?
Yes, sure, happy to. Maybe to start with the obvious, I expect further developments regarding the AI Act, obviously, particularly concerning general purpose AI models, because their requirements will take effect in August this year. So it's not long until this will happen. And this is crucial, especially in my view, because many downstream providers depend on these models when providing their AI-based services or products. And they will also have to rely on certain compliance documentation under the AI Act from these upstream providers like OpenAI and the likes of these companies for their own compliance. So that will be very interesting to see how they are able to fulfill this. And then on another limb, it's obviously GDPR enforcement, which is expected to advance, in my view, which can also potentially lead to significant investigations into the major players or even enforcement actions against the major AI model developers. I personally hope really that the EU will thoughtfully reduce its regulatory efforts while still maintaining focus on investment, which I ultimately believe is also essential for the success of AI in the EU going forward.
Thank you. Marie, what's your crystal ball say for the rest of 2025 and going forward?
I think we've got enough regulation now in the EU to have great businesses, and we just needed a huge investment, and that's what we've done. So I really wish we will implement as quickly as possible that investments so that we can build up a very strong industry, AI industry. But really, all the regulation is there from GDPR to AI acts and so on and so on. So now we just have to invest and have the right industry. And yes, but I'm very optimistic. The only one point is the one I've been raising regarding the transfer of data between the US and European Union, and definitely it would be a nightmare if this decree would be terminated by the Trump administration. It would be a nightmare for our clients, of course. Yeah.
Agreed. And that's something that everybody should be looking at in this week and see what happens. As we started this, let's kind of wrap around. As we started this discussion, we said it's just a breathtaking amount of change just since January of this year. And here we are, March 6th. So we could probably reconvene this group, I would imagine, in another few months and still have a lot to say. So Jason, I'm going to turn it over to you. I don't know if you have any questions for the panel.
I do not. I think it's been a great panel. Unless any of you have last comments you'd like to make, I think we can wrap up. Is anyone else going to make a final statement before I close?
I could say one more quick thing.
Sure.
Just a matter of timeliness. There's a request for information on this AI action plan. This is something contemplated under the Trump executive order I mentioned. If folks are interested in responding, you want to respond by March 15th. So there's a few days left. If you're, this is the, basically they're looking for public comment on it. So if you or your client wanted to provide input to it, it's not clear how that information is going to be used, but they are expressly soliciting input on where the administration ought to go on AI.
Great, thank you, David, and thank you all the panelists for a wonderful discussion of AI and how it's affecting matters in the Europe and the US. And again, I would encourage. Oh, I'm sorry, David.
I see Lisa has her hand up.
Oh, okay.
Yes, thank you, panelists. That was an absolutely wonderful presentation. And I just wanted to, again, encourage those of you who are thinking of attending our conference in San Diego. If you enjoy this, we are going to have an entire AI track So we will get even more in depth on some of these subjects. So I really encourage you to attend, and I thank our presenters so much for their insights.
Lisa stole my thunder. I was about to say kind of the same thing. Please come to the conference if you're all interested. And I hope you had a enjoyable time just like I did. Thank you all. And for most of us, we can return to our days. And Marie and Nils, good evening.
Thank you.
Thank you very much.
Thank you all.
Thank you.
You all. Bye.
Bye-bye.
Bye.